Good morning, everyone. Today is April 5th in the year 2022. The time is 10 a.m. And today we're going to talk about transferring wealth and assets, a little bit of legacy planning going on. My name is Sean Campbell, and this is the California Transition Assistance Program. We're going to be going over a short overview. As far as myself, I'm happy to see everybody today and to have everyone enjoy being here with us. You'll notice that your cameras and your microphones are turned off. We just want to make sure that we can control kind of the flow of bandwidth. And you'll also notice that my teammate will be putting information into the chat. If you have questions, we do ask that you use the questions and answer panel for today's webinar and presentation. As far as myself, I spent 7 years in the Navy, a few years of that blue side, hanging out in the ER, having a good time, and about 4 years of that on the green side, hauling ammunition with a bunch of medical stuff and having fun all over the world with a great group of people. Let's talk a little bit about what is CalTAP. CalTAP is designed to inform and connect veterans of all eras of your state benefits and provide that continued support and assistance, because we recognize that your needs are going to change over time. And we have identified 5 different pathways that we like to really help you as you go throughout your life and make those transitions. Core curriculum has a lot of information about the different benefits out there in the state of California. Education, employment, if you're that person who wants to put your foot forward into your dream, entrepreneurship, and then the different service providers that are out there. And that's one of the things that we're going to discuss today in the webinar. We have one of our great service providers out there that wants to help out and provide you with some really awesome information. You will notice that on our website, on the Calvette website, they do ask you to register, and we do ask that you use a non-DoD email address. Go to Facebook, give us a like on that social media page. And we do have a wide variety of webinars. We'll go over some more of those at the end of the thing today on the additional webinars. But if you take a look at our website at Calvette and use that CalTAP landing page, there's a wide variety of information that's there for you. It's 24/7. You can access it at your convenience. There are learning modules with videos that have that, that also have PDFs, so you can pick and learn at your own pace. And there's archives, as you can see at the bottom where it's circled, of previous webinars that you can enjoy and get that information, because there's a lot of great information about the benefits that you've earned for service members, for veterans, and for their families. So what are some of the California specific benefits out there? Well, there's a college tuition fee waiver for the dependents of disabled veterans, veteran designated driver's license, so you can get that iconography on your actual driver's license, motor vehicle wet registration fee waiver to under certain circumstances, you can get your registration fee waived for your motor vehicle for disabled veterans, reduced fishing and hunting licenses and no cost state parks passes, disabled veteran property tax exemption, and business license tax and fee exemptions. There are a wide variety of counties, so each of those different counties has different rules on that business license tax and fee exemptions. If you look on the right side of the slides, you'll see that there are there's 5 different divisions at minimum inside of the Calvette: home loans, the women's division, the minority division. There's a division for long-term care, and there is burials and cemeteries division as well. The Calvette, we offer a lot of different services that are out there, and we just want to make sure that you take that extra moment and explore the wide variety of things that are there, the benefits that you've earned. In addition to all those things, there's the California Veterans Resource Book. This is an excellent guide. My teammates like to call it a bucket of benefits. It just shows you the wide variety of different resources, tools, and benefits and programs that are out there for you as a service member, as a veteran, and for the family members out there. VA.gov, excellent website, wide variety of options to help you drive your healthcare needs, to look into your records, to look at different disabilities, talk about claims. Just an excellent resource and tool that we really recommend that you use. Here's my contact information and some links to social media. So if you have further questions, we're going to also have a question and answer section at the end of this presentation as well. If you have other questions, you can always contact me and I'm happy to answer them for you. Next up, we have Anthony Rodriguez coming up, who is a local interagency network coordinator. Hello, Anthony. How you doing today?
Good morning, doing great. Fantastic to be with you guys. A pleasure, and what an interesting topic. I'm looking forward to hearing about estate planning myself. Well, let me go ahead and get going and tell you about what I do. I am also one of the other assets, one of the other resources that Calvette provides, and I do that as a link, a local interagency network coordinator. Next page, please. I happen to work out of the Los Angeles region. Now, there's 8 of us who work statewide, and please do look at us as a resource, because what we do is we're required to live in our respective areas, and you can see on the map that we have individuals like myself who work in Los Angeles, Ventura County in turquoise. We have an individual in Orange County, someone in the San Diego Imperial County area. We have an individual that covers a massive area with the Inland Empire, all the way up to Mono County. Someone in the Central Valley area, Central Coast, the Bay Area, and Northern California. So in our respective jobs, next page, what we're required to do is actually live in the area and reach out and get to know the respective community and local benefits and services that are available to you. In our jobs, we go out. I do a lot of presentations on bases. I do several TAP and pre-separation presentations at several bases in my area, but I also present to the National Guard and the reserves and other businesses and or agencies where there's a lot of veterans. So our job is to get to know those resources so that if you were to call one of us, we would not just give you an 800 number, but actually refer you to somebody that we know and work with, someone that we're a part of in one of the collaboratives or one of the various organizations that we belong to. I'm also a member of the statewide Office of Emergency Services. And should there be a disaster in our area, I would be called up to be a part of that team. And my goal would be focused on assisting veterans in particular and military members. Also, I provide leadership and advocacy as required in the various things that I do. Next page, please. For example, yesterday I was at Navy Base Ventura County, and I was talking to a group of retirees, and I was telling them about a lot of these same benefits there. In the area of employment, I work a lot with EDD, but also with a number of nonprofit agencies that work full-time with veterans. I also work in tandem with our local county veteran service offices. And this is the largest network. The state and county through these CVSOs have the largest network of veteran claims compensation representatives in the entire state. They do a pretty good job, and also with appeals. I work a lot on the healthcare side and mental health care side with the VA and other nonprofits and other areas as well. Next page. So the point is that if you need help, if you have questions about anything in particular, and you're in a particular area, give us a call, give us one of the links a call. This is my work cell and my email address, and we'd be more than happy to help you out. And again, thank you for being here. Thank you for your service, and I'll turn it back over to Sean.
Thank you, Anthony. Next, coming up, we have Sheila Marie Finkelstein. Hello, Sheila Marie Finkelstein. How are you doing today?
Good morning. I'm very well, thank you. Yourself?
I'm doing great, and it's great to have you here today.
Thank you. Thank you. It's really great to be here today. Good morning, everybody. Before we really get started here, I want to take a quick moment to recognize and appreciate all of our service members in here. If we were meeting live in person, I'd actually make you stand up so that we could give you a round of applause. But we're not live and in person, so just imagine it right now, because we are truly grateful for everything that you have done for us in our country, and we're here to give back to you. Next slide, please. A little bit about me, because you can't trust anyone as an expert if you don't know what their qualifications are. I'm a certified specialist in estates, trust, and probate law. So what this is it's kind of like, you have doctors. You might go to your family practice doctor, but if you need brain surgery, you're going to go to the neurosurgeon. And if you need surgery, you're going to go to the podiatrist, et cetera. So I am the specialist in the area of estate planning, trust, and probate law. I'm also a VA accredited attorney, and I have an LLM in taxation, which means that when I'm doing my planning, I'm looking at it from a holistic perspective, not just who's going to get your stuff when you're gone, but how do you want to live? And how do you want things transferred? And how do you want to minimize taxes? Because I'm all about keeping everything you've earned to you and yours and not giving Uncle Sam 1 cent more than absolutely necessary. I've also been honored as the 2021 Lawyers Veteran Advocate of the Year because of the estate planning clinic that I founded with Veterans Legal Institute. And I will be telling you about that amazing program later on in our program today. Next slide, please. My why. So I founded Ahava Law. Ahava means love. Everyone who's doing estate planning is doing it because they love someone or because they don't love someone and they want to make sure that person doesn't get it. But in this case, we want to make sure that we're planning for your life with your love. And I've personally experienced it firsthand. I've lost my rabbi, my father, and my grandmother, who were 3 of the most important people in my lives. And I've had to go through the planning and administration stages for all of them. In this picture, you have my husband, a Navy veteran, and my 2 children. And this was my LLM graduation. Next slide, please. So I mentioned my grandmother. I'm deeply, deeply in tune and appreciative of veterans. I have 4 grandparents who are military, 2 Air Force, 2 Navy. My grandmother here, Evelyn Finkelstein, she was actually one of the first women in the military. She was a Navy WAVE, and she was a court reporter in the courts martial. And she was a super successful Jewish mother because she raised 3 boys as a widow, and 2 became lawyers and 1 became a doctor. So very successful on all fronts. Next slide, please. Okay, so let's get into the meat and potatoes of why we're here today. What is an estate plan? Estate plan is basically planning the process of, in short answer, living and dying, collecting all of your stuff, conserving all of your stuff, making sure your stuff is there to take care of you, and then dispersing it in the manner that most efficiently accomplishes your goals. And most people think, oh, I don't need an estate plan. I'm not Warren Buffett. I'm not Elon Musk. I don't have thousands of millions of hundreds of billions of dollars. Why do I need an estate plan? And the truth of the matter is that every estate is planned. It's either planned by you, or if you don't plan, it's planned by the government. So the question really comes down to, who do you want making your decisions for you? You or the government? Next slide. An estate plan is not just one document. Sometimes people think it's a trust or a will, but it's actually a comprehensive package of usually several documents, each one addressing a different component of your life. And so every estate plan is going to be unique to the individual couple or family that are creating it. Generally speaking, estate plans for veterans will include a will, a revocable living trust, nominations of guardians for your minor children, veterans benefits, your powers of attorney for finances, your healthcare directives, and your final disposition instructions. Next slide, please. Okay, so as I've mentioned, estate planning is for everyone. It's essential at every age and every income level. So you need an estate plan when you are 18 and you go off to boot camp. Why? Because you're leaving home probably for the first time. You're going to be inaccessible for a while you're doing your training, and you want to make sure that mom or dad or wife or other trusted person can help you with your banking, help you with your taxes, help you with all of the things that still need to be going on at home while you're away training or while you're deployed and serving our country. It's more than just planning for estate taxes or death taxes. It's about making sure that your finances and your healthcare are taken care of in accordance with your wishes while you are here, especially during times of incapacity. Now, you might be incapacitated because you went skiing and hit your head and you're knocked out for a week. You might be incapacitated because you were injured in the service and now you're in rehabilitation and you can't move around and do what you need to be doing to take care of yourself. And you might be incapacitated because you're 102 years old and you simply don't want to get out and go to the bank anymore. So there's lots of reasons why you might need someone to be able to assist you with your finances and healthcare decisions. I really want to reiterate to stop procrastinating. You do not know when you will need an estate plan. You could walk out the store and there could be an accident tomorrow. And at the time that you need an estate plan, it will be too late because you have to have capacity in order to create the estate plan. So you want to make sure that you're preparing now for you, for your loved ones, and you want to make sure that you are getting all of the benefits that you are entitled to and maintaining those benefits. And I know in my experience, most veterans and service members do not sign up for the benefits they are entitled to. And there are a lot of psychological factors into this. But I'm going to deviate from estate planning here for a second just to tell you, please sign up for your benefits. One, you've earned them. And two, if you don't sign up for them, then the money is not allocated and it's not there in the VA or in whatever program when someone needs it. Those are all based on the number of people who sign up. So even if you feel you don't need your benefits, sign up, register with the VA, get everything you're entitled to, and make sure those funds are there for your brothers and sisters in arms. Now, the other reason you want to do an estate plan is because it is quicker and more private than probate. One of the links that I put out there is a probate calculator, and it will show you exactly, not exactly, but a really good estimate of how much probate is going to cost you. And just know that probate takes a minimum of 2 years, and that was before the pandemic and before all the court closures. So now we're looking at more like 3 years for a probate. And the average cost of a probate, if you're in a house worth about $500K, which in California is really, really easy to do, you're looking at a minimum of $38,000 in probate fees, which in my experience often means the family has to sell the house to pay the fees and end up with nothing. So estate planning is very, very, very important. Also, estate planning is a lot less expensive and more efficient. If you are getting an estate plan through private practice here in Orange County, you might pay anywhere from $2,500 to $6,000 to prepare that plan, which is a lot less than the $38,000 plus for a probate. But even better, I mentioned my estate clinic earlier. If you are a veteran, you most likely qualify for our estate clinic, which is offered through Veterans Legal Institute. And in that clinic, every single month, we prepare complete estate plans pro bono, so for free, for our veterans and service members to qualify. So I also put the link for that. I want to encourage each and every one of you to apply for the free estate plan clinic through VLI. Most likely you will qualify. And on the rare occasions that someone does not qualify, then they'll send you my way. But either way, you're still getting me and my team planning your estate for you to make sure that you're taken care of and things aren't going where they're not supposed to be going. Next slide, please. All right, we're going to start with a will because that's the most common one. Everyone always sees in the movies, you have the reading of the will and it's very dramatic. I'm here to tell you where there is a will, there is a probate. So a will is not actually your be all end all. Essentially, a will is just instructions to the court saying, Your Honor, this is what I would like to happen. Please follow my wishes. And as I mentioned, it will take about 2 years to go through the court. It'll be very public, and all of a sudden you'll have treasure hunters sending advertisements and knocking at your survivors' doors. And there's statutory fees. So according to the California Probate Code, the statutory fee for probate is 4% of the first 100,000, 3% of the next, all set in total. It comes out to be about 5% of the total gross value of the estate, not the net value. So if you have that house worth $500,000 and you have a $499,000 mortgage on it, guess what? Your estate's still paying over $38,000 in fees. It doesn't matter that the net value is less. So a will is necessary, but it's not the be all end all, and it's not ideal. In fact, pretty much the only reason to really have a will is to appoint your guardians for your minor children and to put everything into your trust and say, Your Honor, if anything's not in my trust, I want it in my trust now. Please do that. instead of putting this through full probate. Next slide. A lot of people say, hey, I don't need a plan because I have my house in joint tenancy and I have my bank accounts in joint tenancy. And it says this house is owned by Sally Smith and John Smith, husband and wife, as joint tenants. I'm here to tell you that joint tenancy in the estate planning world is called the poor man's will. And basically it's a poor will for a good man, because it'll work when the first spouse goes, because everything will automatically go to the second spouse. But what happens when the second spouse goes? Or what happens if you both go in the same time? God forbid you're in a car accident. There are so many negative tax ramifications and negative estate planning ramifications that we highly, highly discourage joint tenancy as your estate plan. I've seen cases where you end up losing your step up in tax basis, which means your spouse or your children are paying much higher capital gains taxes than they would actually need to. It means the property taxes are getting reassessed, so you're paying higher property taxes every single year. Worst case scenario, I've seen time where parents have put adult children on the property under joint tenancy, and one of two things happens. Either one, liens are put on for the children's debts, such as student loans or gambling or whatnot. And two, when the surviving spouse passes, it ends up in the name of that one child and not in the name of all of the children. And then that one child gets everything and all of the children get nothing. Or that one child then gives it equally to everyone, and now everyone has had a taxable consequence and everybody's property taxes increase, and it is overall just not a good plan. Next slide, please. Instead, if you own real property in California, if you own a business in California, if you have a family in California, or if you have any assets totaling over $166,250, we recommend a trust. A trust, you can think of it like a treasure chest. You're building this treasure chest and you're putting all of your assets in it, and you're creating a treasure map. And that treasure map is going to tell exactly who you put in charge, what to do, when to do, how to do, why to do, and saying who gets what and when and how. A properly drafted and funded trust is actually going to simplify matters during your lifetime, and it's going to ensure that your wishes will be followed upon incapacity and upon your eventual demise, because so far I haven't met anyone who lived forever. And this is going to set you up for success and simplicity during lifetime and thereafter. Having the trust control your assets ensures that the trustee will have the funds needed to pay any debts, taxes, medical bills, funeral bills, long-term care bills. It is actually super, super important. I've seen this happen where someone has nothing, but they're part of a lawsuit, and the lawsuit ended up settling about a month after they passed. And if they didn't have this trust and we hadn't assigned the benefits of that lawsuit to this trust, their beneficiaries would have gotten nothing. But because we had set up this trust, their beneficiaries ended up getting over $1 million each from this lawsuit, all because we have the right papers in place, all because we have this treasure chest in place. I want to let you know that a lot of times people get their estate planning done while they're in active duty. I know that my first experience with estate planning was when I was clerking with the Air Force JAG at Nellis Air Force Base, and we had 30 people about to deploy in 2 weeks. So I went from never having done an estate plan to doing 30 estate plans in 2 weeks. And that's great, and it's better than nothing. But it is insufficient for California, and all of the plans that they do while you're active duty do not include a trust. They are will-based plans that do not take into consideration the fact that California is a community property state, the fact that we have a higher than average small estate limit, and a number of other things. So even if you have a plan that you did while you were active duty, I highly encourage you to go to Veterans Legal Institute and apply for my estate clinic so that we can get you an updated plan that is unique to your circumstances now and the fact that you are now in California and need more than just the basic active duty plan. Keep in mind that a trust is only as good as what you put in it. So it's not enough to create the trust. We have to actually properly fund the trust for it to be effective. So that means we need to change the title, the deed for your real property. We need to make sure that your bank accounts the title is changed to your trustee. And this doesn't change how you operate on a day-to-day basis. You still are in full control of everything, just as you are as an individual. It just adds in a layer of protection for if you should not be able to control for any reason. Pretty much any type of account you have that has an asset of yours, you're going to want to retitle. Although there are a few accounts, and when we meet, that's a topic for a different day because we could go on it for hours. But there are a few types of accounts, such as retirement accounts and life insurance plans, where instead of retitling the plan or the account, you want to make your trust the beneficiary of that account. And the reason is a lot of times people put their spouses or their kids as the beneficiary. But how that works is if you put your kids as the beneficiary and something happens to you while they're underage, it is locked up and they cannot touch it until they're 18. And then when they're 18, they get everything all at once. And I don't know about you, but when I was 18, I did not have the wherewithal to manage a large windfall of money and probably would not have used it responsibly to last the rest of my life. So you want to make sure that everything is properly titled in or beneficiary designated as the trust. Next slide, please. So as I was mentioning, you want to have the trust as the beneficiary of any tax deferred accounts, such as retirement and life insurance. But you want to make sure that the trust is set up properly. There's been a lot of law changes, especially recently with the Secure Act. So you want to make sure that there is either the proper conduit language or accumulation language. You want to make sure that within the trust itself that you are specifically and directly naming the beneficiaries and pointing out if they're minors or if there's any special needs planning that needs to be done. Maybe you have a child with autism, or maybe you have a child that's been in an accident, has an injury. We want to make sure we're taking care of all the potential special needs, either known or in the future. There are a few limited circumstances where you might want to do either a retirement trust or an irrevocable life insurance trust. But again, that's very specific to your circumstances. So I can't say in a forum like this what would work for you, other than pointing out that those are some of our options. Next slide, please. Okay, the next part of the estate plan is one that you're probably familiar with. It's called a power of attorney or a durable power of attorney for finances. What this is a specific written authorization allowing a person to act on behalf of another person in their financial, business, legal affairs. You could have something called a limited power of attorney, which is limited in scope to one thing, authorizing a person to purchase a car on your behalf. Or you could have a general power of attorney, which covers all the things, talking with the IRS, talking with Medicaid, talking with the bank, etc. You want to have this in place, whether you have nothing or whether you have millions of dollars, because you want to be prepared for situations in which you may not be able to act on your own behalf, either due to absence or incapacity, such as if you're traveling, if you're stuck in a foreign country, if you're deployed, if there's been an accident, maybe you have an illness and so you're temporarily unable to handle your affairs. These are all reasons that you would need a power of attorney in effect. Next slide. Another type of power of attorney is called the Advanced Healthcare Directive. Pretty sure everyone in here has this because that's one of the forms that they make you do during the military. But again, you want to update it to what's applicable here and now. And the Advanced Healthcare Directive, you're going to decide who makes the decisions if you can't make your own medical decisions. And you tell them what kind of decisions that you want to be made. Maybe you're a Jehovah's Witness and you don't want any blood transfusions. Or maybe you want to pull the plug because you don't want to be kept on artificial life support for 20 years. The choice is yours to make. And we want to make sure that you're making all of the choices while you have the full capacity to do so, so that you don't put your loved ones in the position of having to decide whether to pull the plug or not to pull the plug, having to decide whether to authorize the surgery or not authorize the surgery in a time of complete chaos and crisis when they're worried sick about you. You want to make sure that you make it as easy as possible for them. Next slide, please. Okay, so something unique to planning for veterans is in our final disposition instructions, instead of just saying, I want to be buried here or I want to be cremated there, we also have a really, really great form. It's the pre-need form. I'm trying to see the numbers on it, but it's too small right now. Sorry. I believe we're sending this slide out, so you'll see a copy of it on the slide. But what you do is you fill this out, you attach a copy of your DD-214 and you send it on in now, and you'll get the letter back saying that you have eligibility to be buried in a veteran cemetery. It used to be that you had to die first and then your loved ones got to do this process and try and figure it out. But one of the things that has improved is you can now do it as soon as you're discharged. And also keep in mind that your spouse is eligible to be buried with you. So you would need to do a separate form for you and for your spouse. And you can be either cremated or buried. You'll want to make the arrangements for cremation and burial with your home cemetery or your home funeral parlor. But then they will transport you to the VA and you can either be in one of their columbariums or in one of their plots, depending on where you've gone and what the options are and what your choices are. So very important, even if you don't do any other estate planning today, you might want to go ahead and print this out and fill this out and send this in so that you've got one thing checked off your list for your loved ones. Next slide. Okay, let's talk about fiduciaries. So a fiduciary is the person that you've named to be your trustee or the executor of your will or your agent under power of attorney or your agent under healthcare directive. These are it can all be the same person, it can be different people, but you want to make sure that it is someone that you trust explicitly. You want to make sure that you're considering family dynamics. You want to consider any conflicts of interest. You want to determine capacity. Maybe your sister is the best person in the world to be your fiduciary, but she also has 4 children under 4 and is a school teacher and dealing with diaper training. Might not want to put the administration of your estate on her right now. Might want to wait until the kids are grown up and she actually has the sleep and the brain capacity to deal with this. Also, you want to look at who the players are. If is this a best friend that you're picking? Is it a beloved, affable, loving Uncle Bob who's all jovial and is kind of like Santa Claus? And do you really want to make him have to be the bad cop controlling the money for your child who's like fast and furious and drinks too much? So you got to look at the whole totality of the circumstances and make sure that you are designating the appropriate people for your trustees and your fiduciaries, and making sure that you trust them explicitly, that they understand exactly what it is that you want done. So make sure you're talking with them too. And also make sure you're not going against their beliefs. You don't want to make super strictly religious Aunt Sue the one who has to pull the plug on you if that's against her religious beliefs, because just think of the position that you're putting her in. So you're determining your fiduciaries is very, very important. This is probably usually the longest part of an estate planning process, is just figuring out who these people are. And I always recommend you have at least one backup, because especially if these are people like, and trust, it's quite possible that you guys might all be in the car together when something happens. And so you want to make sure that there's a backup. Or if they're older than you, you definitely want to make sure there's a backup, just because natural progression. Next slide, please. The next big part is the beneficiaries of your estate. Now, this is the part that everyone really thinks about with estate planning: the reading of the wills, who's getting what, do you get it outright, does it stay in trust forever and they can only have a little bit each year? What is going on? Your beneficiaries can be individuals, They can be organizations, charities, etc. Your beneficiaries can be whoever you want them to be. There's a Disney movie where a dog is the beneficiary, and that's accurate. You can, in fact, create a pet trust that says everything in your estate is used to take care of Fido, and nothing anyone can do about it until Fido's gone. So you want to make sure to put those protections in place, saying that, you know, Fido has to live and be taken care of, etc. But that's one of the few things that the movies get correct, is anyone you want can be your beneficiary. I want to remind people that there is a difference between what is equal and what is just. So you want to consider your personal family dynamics and needs. For example, you might have 3 children, and one's a doctor, one's a lawyer, and one was born with Down syndrome and will not be able to fully provide for themselves for their entire life. Well, what's equal would be to give each child 1/3, 1/3, 1/3. But is that really going to be just? You might find that in your situation, in that situation, that the doctor and lawyer are perfectly fine of taking care of themselves, and instead you want to put everything into a special needs trust to make sure to take care of your child that needs the extra assistance. Another thing to think about is that you don't have to leave anything to your children or your family or your heirs at law. Not only does it not need to be equal, but you can say, nope, you get 0 zilch and everything goes to my charity of choice. Everything goes to Calvette, or everything goes to Veterans Legal Institute, or insert your favorite organization here. And that's okay too. So the truth of the matter is, whatever you want to do, as long as it's legal, you can't leave everything to the mob. We can put that in writing. We can make that happen. So if you want something other than whatever the government says, which if you're married in California, it says it goes to your spouse. But if you're married in California with children, it says that your spouse gets 1/3 and your children get 1/3 and 1/3. And maybe you don't want that because your children might be under 18 and you want your spouse to get everything and take care of your children. So there are a lot of different things to think about here, and make sure that what you want is what happens and not what Uncle Sam says in the probate code. Next slide. Let's talk about life insurance. Life insurance can be a wonderful tool, and everybody loves it because they think that it's tax-free, but it is only income tax-free. The value of your life insurance policy at the time of your death is includable in your estate for estate tax purposes. So if the estate tax, right now the estate tax exemptions is $11.7 million. So I'm going to imagine that most of us here on the call today are not going to be impacted by that. However, if they change those exemption amounts, like such as, you know, when I was in law school, the exemption was only $600,000. Well, if that's the case, then anyone who owns a house in California is now going to be subject to those estate taxes. So a lot of this will depend on what the laws are in place at the time, but it's very important to know the difference between who the owner of the account is, which estate it's being included in, and who the beneficiaries of the account are. This is something that I would say consult with myself or another experienced trust and estate attorney to make sure that everything is set up properly with your life insurance. Next, please. Now, a revocable living trust is called a living trust because it should be a living document. So you want to make sure that you're reviewing your estate plan every single year. I say do it when you're doing your taxes. But at a minimum, anytime you have a life cycle event, a birth, a death, marriage, divorce, adoption, establishing or selling a business, retiring, inheritance, buying a new home, anytime something big changes, you want to make sure you're looking at your estate plan, because you don't want to end up with the case where you have an estate plan and then next thing you know, the person, you know, your ex-husband's sister is ending up with your assets because you didn't update your estate plan. I've actually seen that happen. So make sure you look at your estate plan. Like I said, do it every year when you do your taxes. Make sure that it has all of your current assets listed on Schedule A. Maybe you bought a new home. Maybe you got some new toys, you know, such as boats, RVs, etc. Make sure it's up to date and says accurately reflects what your current status is, what your current family dynamics are. They are quite easy to change. You just go through the process of doing an amendment or restatement, re-sign, re-notarize, and you are done. You can change this up until the point that you lose capacity or die. So make sure that you are reviewing it every year, especially because even if nothing changes in your life, the tax laws might change, or the property laws might change, or other things might change that could impact the way in which your plan should be drafted. Next slide, please. This slide has all of the information for the Veterans Legal Institute. As I mentioned, we do an estate planning clinic pretty much every single month. So if you are interested in getting a plan, please go to vetslegal.com and they have the application. Once you've completed the application, then there will be either an individual or a married estate questionnaire. So it'll depend on your circumstances, of course. And in that questionnaire, you're going to put things like, who do you want to be your fiduciaries? Where do you want your stuff to go? What kind of decisions you want made? Once you've completed that, you'll meet with our estate planning team, which is usually myself and a couple of other attorneys who donate their time, including a Vietnam veteran who's amazing, and my newest attorney who is learning so fast. And so you get a whole team working for you. Once we've met with you, we'll talk with you, we'll decide what type of plan best suits your needs. And then we'll send you a summary or draft of your plan for you to look over and say, yes, this is what I want. And once everything is good, we will schedule you with a notary. So we used to meet in person before the pandemic. Because of the pandemic, we have now been meeting via Zoom, which actually has allowed us to reach out and help more people. And now we can do a remote online notary, which means you just log on, you get everything signed, sealed, and delivered to us on the same day. And then the final step is we record your deeds, if any, and fund your trust. So all of this usually would cost between $2,500 and $6,000. But for our veterans coming through the clinic, the only thing that you pay for are the fees to record the deeds, which vary between they average about $100, and the minimal notary platform, which is also about $50 instead of thousands of dollars. And I wanted to be sure to leave time for questions today, and I see a lot of chats and questions, so I'm going to take a quick look. Okay, so in the chat, you'll see some links that I've provided. The first one is resources for veterans from Ahaba Law. That's my law firm, and we have a whole page listing out different resources available to veterans, and I highly encourage you to take a look at that. We also have my main website page. It is very, very, very important that you have, at a minimum, a power of attorney for finances and an advanced healthcare directive. If you don't want to talk with me or another attorney to get it done, and if you don't want to go through the clinic, then go ahead and click on the free estate plan button on my website, and you can print one and fill it out yourself. Keep in mind that it is not legal advice, and it may or may not suit your purposes. It is really just the bare minimum to make sure you have something in place. We talked a little bit about probate today, so there's a link for the probate calculator if you want to see, how much a probate would cost your family. Just go to Zillow or realtor.com, look up the current value of your house and input that number, and you'll see what the minimum amount that you will be paying for probate is. There's the link for Veterans Legal here, so you can just click on that. You can start the application right this minute to apply for the VLI Estate Clinic. And then I've also included a link for the Orange County Bar Association Veterans page. This is something that I created as a part of the Veteran and Military Committee. It has two objectives. One is to teach the attorneys in Orange County about the legal protections available to veterans. And the other is to provide resources for veterans for housing, consumer debt, healthcare, employment, all the different types of law. So it's a really good resource to use in addition to accessing Calvette. And it is it's specific to California and more specific to Orange County. Someone asked about a copy from the chat. I don't know what that means. And okay, so now is the time. Please put all of your questions into the Q&A part, because we've got about 15 minutes and I want to make sure that I answer any and all questions that you have today. Scott, you're on the panel. Thank you so much. The VA form is VA form 40-10007. That is the pre-need form to make sure that you are eligible to be buried in a veteran's cemetery. Would VLI be able to work on an estate plan or living trust already set up that needs to be updated? Absolutely. Bring that in when you submit your application, send it to us, and we will do what's called a restatement. More questions. Ooh, good, we're going fast. We would like the links in an email if you could. Yes, I think Calvette has Danielle or someone working on that. They will send you an email with all of the links that we've provided today. Retired military with a special needs child, 29-year-old dependent son. He and my wife both signed up as SBP beneficiaries, premium deducted. When my wife and I are both deceased, he will receive 55% of my retirement pay for the rest of his life. This is problematic because special needs child would lose his SSI, Medi-Cal, etc. Okay, yes, all of this is true. So you want to make sure that in your trust, you also set up a sub-trust for this child, a special needs sub-trust, and that special needs sub-trust will have specific language in it that allows the proceeds from your retirement pay or any other assets that you have to be used for the supplemental benefits of your child, meaning to pay for the things that their SSI, Medicaid, etc., does not pay for. But because your child will never have control of them, they will not be counted against them for purposes of their eligibility. So it is really, really important that you set that up now and you set it up properly, because if you don't get it set up now, then he will in fact receive those retirement benefits. And even if he sets up a first person trust, special needs trust later, because he is under the age of 65, it will be too late. He will lose eligibility at least for a specific time, because he will be considered to have had control over them and then to have given them away to the trust. And so that could negatively impact him. Very important that you update your estate plan. The link works for Orange County, but not Northern California. Scott, let's make a note of that. I don't know if there's anything similar in Northern California, but I do know that it works for more than just Orange County, because I know we help with Riverside and San Diego, and there's an LA as well. So we'll look into that. Yes, San Diego residents can go through the estate clinic. There are not yet other branches of the Veterans Legal Institute. We are the first of our kind in the nation. And when we started in 2014, we really disrupted the pro bono legal service providers clinic, but we are working to expand to not only be California-wide, but also nationwide. So just give us a little bit of time for that. But in the meantime, you can reach out, and we do have a list of attorneys who like to help out and volunteer with our veterans. And so if you don't qualify to get service through the free clinic with VLI, we can connect you with an attorney who can help you pro bono or low bono.
I just want to interject. I'm not sure why anyone's not able to copy the information from the chat, but please go ahead and send me your email. You can do that in the chat section, and I will get the information to you for those of you who are able to access that. I do have an email thread going right now, and I have sent it to several other people. So if you are needing to get access to the links to the PowerPoint presentation, please go ahead and send that email, and I'll be handling that as you guys continue to answer the questions.
Fantastic. And I feel like I interrupted Sean, who was about to say something too. Sean, you want to say what you were going to say before I answer the rest of the questions?
No, not at all. You're on a roll. Oh, you got it.
Okay. It looks like this question was a continuation of the one for special needs. Yes. Okay. So we are familiar with these processes. There are certifications to the trust, attorney certifications. Again, it's very important to make sure that we set up everything properly from the beginning so that it never has a chance to be in your adult child's estate. Also, depending on the circumstances, there are certain things in California, such as an ABLE account, that can be used as long as the special need requirement was before the age of 24, I believe it is. I'd have to double check on that. So there are a number of different programs available. I also want to make sure that anyone who is receiving VA benefits, there is specific planning that can be done for that as well to make sure that you're not losing your eligibility for your VA benefits. It's similar to special needs trust, but it is its own different entity, and you might have both. So again, it all depends on your family and your circumstances. I do not believe that your children can be, or your special needs child can be laid to rest in a veteran's cemetery with your wife and yourself when the time comes. But I can do more research on that, but top of head, only you and your spouse can be buried in the cemetery. Yes, confirming that the service areas for Veteran Legal Institute are Los Angeles County, Riverside County, San Bernardino County, Orange County, and some of northern San Diego County. San Diego also has a lot of resources of their own as well, so it kind of depends on where you are. Will we get a copy of the presentation with the slides and a copy of the presentation, but not the slides? I think Danielle answered that. Are there local advocates to assist with the will and the trust in the Bay Area? Yes, please reach out to Veterans Legal Institute and we will give you the referrals for the attorneys we have connections with in those areas. And you'll be moving to San Diego in the next year or so. Congratulations, that's a wonderful place to live. It's always great weather. Oh, yes. If you look at local law schools, a lot of law schools, now that we have VLI, have started creating veterans clinics. So if you go to the local law school in your area, then they may be able to help you also pro bono, because it's a chance for the law students to learn how to do what it is that I do. Once a VLI clinic application is submitted, what is the approximate time frame for approval and access to the clinic resources? And I'm in LA County, would I be approved? Yes, LA County, you can be, and it depends on when you submit your materials. So once you submit the online application, it goes through the team that determines eligibility and then passes it off to the estate clinic or the family clinic or the VA benefits clinic or the discharge upgrade clinic. So from the time it gets funneled to us, we immediately send the questionnaire. So that might be like a week or two, depending on how long it takes. And then the next step is really up to you. We have some clients who give us the questionnaire that same day, and we schedule them for the next estate clinic. The clinic is usually held on the third Thursday of the month. So if you get it to us before then and we're able to get you scheduled for that clinic, you could, in theory, be done in as quick as 5 or 6 weeks. If you don't get the questionnaire back to us, we will not schedule you for the clinic, and you'll have to wait for the clinic the following month, in which case it could take 2-3 months to get done. So a lot of it depends on you. But from the time that we meet with you, it's less than a month for us to draft your plan and get you set up for notarization. When we were doing it in person, it was exactly a month, because you'd come to the one clinic, have your initial meeting, and then you'd come to the clinic the following month to have your signing meeting. But now with the remote notarization, we're actually able to do it a little bit quicker. Does the California Statutory Estate Plan apply across all states? The short answer is yes. We have the full faith and credit clause, which means anything that is legal in the state in which it was done in terms of your estate planning will also be honored in the state in which you reside or pass. That being said, I believe there's only 8 community property states in the United States, and California's version of community property is different than some of the other states' version of community property. So I do recommend that when you move to a new location, you contact a local attorney to make sure that everything is up to date and copacetic with the local and state laws of where you reside. But you don't have to do it very first thing. Your California plan will cover you until you do update it to a Nevada, Texas, or whatever state you happen to be in plan. What happens if the trustees you name predecease you or decide not to be your trustees? Excellent question. This is why we say make sure you talk to them before you appoint them, because you want to make sure that they will say yes, or most likely will say yes when the time comes. This is also why you want to name backups, because in case someone doesn't want to or is not able to, or maybe they're just out of the country and unavailable, you want to have someone to go down the line. But also, when we're preparing your estate plan, we do set up contingencies. So you can say things like, if there's no trustee in place, then the court is to decide a trustee, which is not my favorite, because that means you're going into court when one of the main purposes was to stay out of court. Usually what I would do is appoint something called a trust advisor or trust protector, and that's a person who you appoint, or you have the ability to appoint, who could then appoint a trustee on your behalf or on your trust's behalf. It's a little bit complex, but we absolutely take that into consideration when we're making your plan, because we want to make sure that under no circumstances are you left without someone in charge. Someone said you wrote a question in the chat. I'm sorry, no problem. I will take a look at that in a second. How can I obtain a recording? That is not a question for me. And legal assistance extends to family trust. Yes, if you come to VLI and you are married, we will do a married estate plan for you. If you come to VLI and you are married with children, we will do a family estate plan for you. So the plan we prepare for you is going to be pertinent to your specific situation. In LA County, for the application for Veterans Legal Institute, just answer the question about your county as yes to circumvent the glitch there. Kimberly says on the Calvette website, it does say that under certain conditions, an unmarried adult child with disabilities may be eligible for burial. Fantastic. That is where we will start our research. Thank you, Kim. Oh, here's a really great question. Once you retitle your real estate assets under the living trust, will that trigger a taxable event, and will that increase your property taxes? Excellent question. The answer is no. There's something called the St. Germain Act, which says that if you have a mortgage on your property and you put your property into a revocable living trust for your benefit, they cannot call the mortgage due. So they can't do anything. It's treated as if it is you individually. And it is not a change in ownership. It is just a change in the manner in which title is held. So it's the same as if you're doing something between spouses, or if you changed your name. It's saying, hey, it's still me in charge, just under a different format. There is no, for that same reason, there is no reassessment for property taxes. I do want to point out, however, though, that reverse mortgages do not follow the same rules and regulations as a regular mortgage. So if you have a reverse mortgage, you may not actually be able to title your property at this time, because that might trigger the full mortgage coming due within 6 months or immediately, or whatever the fine terms in the contract say. So what we do in those cases is we prepare the deed, we notarize the deed, and then we do not record the deed until your passing or incapacity if necessary. And so that becomes what we call a pocket deed. And the reason we do that is because it shows your intent. It allows us to do the transfer in the quickest and most efficient, easiest way, but we won't trigger the mortgage coming due and payable until you've passed, at which point the mortgage is coming due and payable anyway, because it's a reverse mortgage. And for the most part, I highly, highly recommend against reversed mortgages. I know that they can be a useful tool, but in my experience, They tend to mess things up. I'm actually in court right now. A family who had a trust and did everything right, but they did not have that pocket deed, has now spent over $42,000 in legal fees, trying to prevent the house from being foreclosed upon by the reverse mortgage company, because they didn't have that pocket deed. So even though they have a buyer for the house, they haven't been able to sell the house because we have to jump through all these legal hoops first. So if you can avoid it, please do not do a reverse mortgage because it really complicates things. And if you do a reverse mortgage, talk to me or some other attorney who's very knowledgeable in this area so that we can make sure you are protected. One of these must be true. Oh, good. Okay, so John Kirk's providing the information for the minor child's burial. Further information. The person qualifying for the burial benefits is a veteran who didn't receive a dishonorable discharge, or the person qualifying is a service member who died while active duty. There's a lot of details here. Maybe we, Sean, maybe we can do a separate presentation on this, or at least a separate document to send everyone out.
Okay. We're happy to do that.
Does my original pre-deployment will and power of attorney from 2005 still stand if I have not updated anything since? The answer is it depends. If it says that it is durable, then yes, it does not. If it has an expiration in it, sometimes I've seen them where they have a 1 or 5 or 10 year expiration, then it will no longer be valid. But either way, it is stale, and I highly recommend you get a new one. No, we're not in the Central Valley, but we would be happy to connect you with resources there. Yes, it is a good idea to keep the backup trustee informed on the progress of the trust administration. Usually they will naturally be. It's my experience that people usually say, you know, oldest child, middle child, youngest child. So by virtue of being a beneficiary, they will be apprised. If they are not a beneficiary, then you want to give them a phone call once in a while and keep them up to date. You do not, the question is, can you put a Calvette mortgage into the irrevocable trust? You do not want to put a mortgage into a trust for lots and lots of reasons. And for the most part, you do not want an irrevocable trust except for in very, very specific reasons. Today, we only talked about revocable living trust. Irrevocable trust is a different topic for a different day, but be very, very, very careful with them. Speak with me or another attorney first. What is the impact of Prop 19 to estates? Another excellent question. So before Prop 19, it used to be that mom and dad could give children their primary residence and a secondary residence, and the children got to keep the low property tax basis from whenever mom and dad bought it. Unfortunately, Prop 19 took that away completely for the secondary residence. And for the primary residence, in order to maintain that low property tax basis, now it has to have been mom and dad's primary residence, and then child has to move into it and make it their primary residence. And it will only maintain that low property tax basis as long as it is the primary residence of the beneficiary, and as long as the difference in value is not more than $1 million. So if your property went up a whole lot since when they bought it, you're probably going to get at the very least a partial reassessment. It's terrible, terrible, terrible. I voted against it, but I guess not enough people did. Is the trustee obligated to provide requested information that is not covered in the trust? No, the trustee is only responsible for the materials in the trust. However, if the trustee is also the power of attorney or the personal representative or the executor, they may be responsible for providing the information under those hats. So it depends on where the information is coming from. But yes, there is full transparency, so you can't hide anything. And if you can, you will be removed and probably fined. My dad is a Korean disabled veteran. He has Alzheimer's and dementia. Can I help my parents with planning? It depends. Having Alzheimer's and dementia does not automatically mean that you do not have the capacity to make a plan, but it's quite possible that he does not have capacity to make a plan. So your first step in that case would be to have his primary care physician prepare a letter saying that he either has the capacity to make a plan or that he does not have the capacity to make a plan. Fingers crossed that your doctor says that he does, so that he can in fact put together an estate plan before the Alzheimer's and dementia progress until he can no longer make the plan. Okay. We've got a few more minutes. I know we're going out, so if you have to leave, thank you so much for joining us today. But if you don't, I'll just take a couple more minutes to answer the other questions that I see. And I'm going to just scroll from the bottom to the top because there's quite a bit here. Okay, we put in the information on the dependent and the spouse. Thank you very much. If my property was purchased with a VA loan, will I have a problem passing my house to my beneficiary? Nope, absolutely not. If you pass a mortgage, a regular mortgage, not a reverse mortgage, to a beneficiary, they have the option to just keep paying it as if they were you, or they have the option to assume the loan, or they have the option of refinancing it. But the VA loan, for the most part, the VA loan is really amazing, and I haven't had any estate planning issues with VA loans. Other loans, yes, but VA loans, no. Okay, copy of the slides. Absolutely. Answered that one live. Oh, there's a lot of you guys here today. Thank you so much for joining us. Okay, my father passed a couple weeks ago, and being there, I found while a trust was intended, his investments went into the trust, but not the sold house value. Can we disperse the shares and whatnot through the trust? Okay, I'm going to ask that you go ahead and contact us personally. We may be able to help you with something called the Hegstad petition, but that's a really specific question, a topic for a different day, but please do reach out. And I'm really, really sorry for your loss. I know firsthand how terrible that is. All right, Sean, did I miss any? I think I've got them all here.
There's two more that went over to the Q&A. And Sean, if you want to go to the next slide so that people have a chance to look at Sheila's information and our contact information again. So that way, if I have missed anyone's email, you can email me directly, or you can hear me personally, or you can email us at caltap@calvet.ca.gov. Either way is fine, but I do have that email going. It does have all the links and resources, as well as the link to our YouTube page where you can find the recording. It takes anywhere from a week to 3 weeks. It's a whole nother team that takes the recording and puts it on the website, so we don't have any control of when it will be available. And I also am going to attach a copy of the presentation. So that email will come. I'm not hitting send yet to make sure that I get everyone's emails in there, but it will come out shortly.
Fantastic. Okay, next question. Can I put the living trust under an LLC in a strong asset protection state, such as Wyoming or Nevada? Can the mortgage company call the loan if the assets are held under a corporation? So we often do what's called a privacy trust, where we actually have the trust own the LLC. It can be done in reverse, but just know that if it's a California LLC, or if it's a non-California LLC, but it owns property in California, you are not escaping California's jurisdiction, and you will still be paying the minimum California taxes of at least $800. So before you go into these asset protection lines in out of state, consider what your options are here first. But yes, there are lots of complicated planning that we can do to remove assets from California. And yes, the mortgage company can call the loan if you switch it into a corporation, because a corporation is a separate entity, whereas a trust is still considered as the same individual owner. Also, you may have potential property taxes if, for example, you change a property from your individual name to an LLC held by you and your brother. That is also considered a change in ownership, and the property taxes will be reassessed. So be very, very, very careful with that kind of higher level planning. Can a will disinherit the children? It absolutely can. And I would also recommend disinheriting the children in the trust. That way you've got them covered on both aspects. And I do not recommend, you've seen the movies where they say, well, leave just $1 to that disinherited child. Nope, no way, absolutely not. That is a terrible idea. Much better to say, this child is disinherited. If you want, you can even say the reasons why, or perhaps you put that in a private letter so that it's not part of the trust itself. But yeah, like I said earlier, you can give your stuff to whomever you want in whatever ratios and percentages you want. So if you don't want your kid to get something, either because they won the lottery and they don't need it, or because they are schmucks who caused a drunk driving accident and you don't want to reward their behavior, whatever reason it is, you can disinherit them. All right. I think we've got everybody. Again, thank you so much for your time. It's such an honor to be able to be of service to you and your families, and we truly appreciate everything that you have done for us in our country. And we look forward to working with you again soon through Calvette, and we look forward to helping you through the Veterans Legal Institute.
Thank you again for coming on and giving such an outstanding presentation. And I want to thank Anthony and my teammate Danielle as well. I want to thank everyone for participating in the webinar today. Our contact information is on this slide and it's available if you have any follow-on questions or you want to have a look back at some of the information. We're happy to get back to you as well. Thank you everyone for your time. And it's 11:11 and we're going to end the webinar at this time. Thank you very much.